Okay, good afternoon. Welcome to the Thurston County Board of County Commissioners Budget Work Session. It's Friday, October 8th, 2021. It's 1:33 p.m. My name is Tem Time, Chair of the Board. To my right is Commissioner Carolina Mejia. We have County Manager Mira Chavez and Assistant County Manager Robin Campbell. We expect Commissioner Edwards in any moment. We have three budget presentations in this work session. The first is from District Court, second, Prosecuting Attorney, third, Public Defense. The schedule will be 45 minutes with 15-minute breaks in between, but we'll be on this one live streamed presentation through our YouTube channel. And that should get us going. We've got our team from District Court on the screen, I see. So we'll just go directly to our Judge Buckley. Welcome, and we're ready for you.
Thank you, Commissioner Menser, Commissioner Mejia, Mr. Chavez, and Ms. Campbell. Good afternoon. Nice to see everybody. I'm Judge Brett Buckley, presiding judge, Thurston County District Court. Have been so for a long time. With me today is Frankie Peters, our court executive officer. I think all of you now know Frankie. Frankie is succeeding Jennifer Creighton, our former court executive officer, and Frankie used to hold the position of court operations officer with us. And we're really lucky to have Frankie in the position of succeeding Jennifer and continue that line of strong leadership for District Court. As you know, District Court is a limited jurisdiction trial court for the county. We are the folks who see the most number of people as far as court activity goes. Criminal cases, civil cases with jurisdiction up to $100,000. Infractions of traffic and other sort, and protection order cases. We are also the county's mental health court and veterans court. We currently have 34.75 FTEs, and Thurston County District Court also serves as the municipal court for the cities of Lacey, Tumwater, Rainier, and Yelm to the extent that we do their jury trials, and Yelm is currently negotiating a memorandum of understanding with the county to allow us to take Yelm criminal defendants into our therapeutic courts, mental health court, and veterans court. The Thurston County District Court's mission statement is serving justice through serving people. That guides everything that we do. From our day-to-day work in the court, among staff, and in making budget requests. And that mission statement was particularly meaningful to us and helpful to us in the last year and a half, going on 2 years now, as we have dealt with the COVID situation that all of us are dealing with. In March of 2020, in consideration of all the factors being presented to us by public health and both locally and nationally, we made the decision to close the court to the public in consideration of the health needs of our staff and the court users and members of the public. We, however, did not stop conducting the court's business. We're not doing jury trials. That is one court business we did stop. But we started immediately transitioned to virtual hearings, and we had a leg up on that because for many years we had been doing hearings from our jails, both the ARC and the Nisqually jail for Lacey and Tumwater incarcerated defendants. We've been conducting video hearings with those folks for a long time. So for us, the transition to conducting virtual hearings was fairly seamless. And because of the obligation for public access to judicial proceedings with a locked courthouse, we had to come up with an alternative, and that was to live stream all our judicial proceedings. So that's what we did. We have, I think, 3 or 4 YouTube channels upon which we live stream all of our proceedings. And as we've opened up, we continue to live stream. And this had been a goal of the courts for a long time prior to the pandemic coming around, was to live stream these to allow greater public access to judicial proceedings and an understanding of what goes on in the judicial branch of government. So in this sense, the COVID virus provided us an opportunity to accomplish something that we had been struggling to accomplish in years leading up to that. Now, having gone to full virtual hearings in March of last year, we did make arrangements for folks who did not have the proper technology access to notify us, come into court, get a private room. We would provide them with a tablet, and they could participate in the virtual hearing that way. And as we developed this policy, we were had a lot of discussion about it, and spent a lot of time trying to design how we would handle those folks who did not have the same level of technology access that others did. And just anecdotally, from my perspective, it's been amazing how few folks indicated they did not have technology access and how many folks did have technology access of one sort or the other. And, you know, one of the things that just strikes me, and I'm sure is applied for you, all of you too, since you conduct your meetings much the same way, is how convenient automobiles have become, not only as means of transportation, but as studios for virtual meetings and hearings. And so the number of folks that are sitting in a car conducting a hearing has been striking to me, whether it's on phone or on some other device. Anyway, I think our community has adapted well, and the court has adapted well, in my mind, to the challenges presented by COVID. In April of this year, thanks to the county arranging Chandler Court space for us to use, we restarted jury trials. The reason for needing that space was the largest courtroom we have in the district court building, courtroom number 1, is not of sufficient size to have proper spacing to conduct any sort of either large calendar or a jury trial. There just was not room in that place for jurors to spread out, for parties to spread out, and to have any members of the public present. The space provided in Chandler Court does that, and we have conducted a number of jury trials there, not as many as we would like. Our hope was that we would be, by this point, conducting 2 jury trials a week there. We have not yet. In fact, we have some weeks where we're not conducting any jury trials, and there are, you know, a whole host of factors that go to that, even though we are scheduling jury trials every week for that location. It is a good space. However, I just need to note that we do have ventilation problems in that space, much like we have in Building 3, particularly in consideration of the COVID situation. Having good air movement in a facility is really important, and it just doesn't seem to be up to the level we would hope for at the Chandler Court location. I will make a note that we did something somewhat unusual as we restarted jury trials, and that is that our first jury trial, which I conducted, we did a virtual voir dire being the jury selection. So rather than ask the 20-something people, and I don't mean age, I mean number of people, come into court for jury selection and have to be with others who, you know, they don't know if they've been vaccinated, if, you know, what their health status is. We allowed them all to remain at home and got in a private room at their home and conducted our jury selection process that way, and then asked the 7 people who were selected for the jury to come in the next day to serve as jurors for the trial. And both upon concluding the jury selection process and asking jurors that day, and then the following day asking the jurors who were selected for trial what they thought of it, and they were all enthusiastic supporters of the willingness of the courts to allow them to appear remotely for the purpose of jury selection, thus reducing the contacts with other people and the likelihood that there would be a spread of disease related to participation in the jury trial. So that is something that we have done, something we can do if the disease flares back up again this winter. Pleased to see that the numbers are not going up as fast as they were before, and hopefully we continue in that trend. In July, we reopened the courtrooms to the public to allow the public to attend our judicial proceedings. And as I mentioned earlier, we have not changed our process as far as live streaming our proceedings on YouTube. We continue to do so, and we just anecdotally get more people observing by YouTube than we ever would have coming into the courtroom when prior to the pandemic, for example, when that's what the standard way of seeing a court proceeding was. So I think the idea of live streaming these proceedings has really improved the public's access to what happens in the courts. September of this year, just like the county, the court imposed a vaccine mandate for all staff. And to date, we have all staff vaccinated with the exception of 3 staff members who have been granted religious exemptions. As the accommodation to that exemption, those staff members are required on a weekly basis to engage in COVID tests, and no self-tests, no rapid tests, but it has to be a lab test, and provide us the test results by Monday of the start of the work week in order for them to be able to work that week. Now, the adjustments to the pandemic notwithstanding, we have a significant backlog as a result of that. Right now, our backlog sits in the general neighborhood of 1,500 cases. At this point, we are basically breaking even on the new cases coming in and the cases that are getting resolved. So we're sort of static with that 1,500 number. We are working with our partners, the attorneys, and law enforcement folks to try to figure out how to begin to have that number move in a more positive direction so we can reduce the backlog. But honestly, the primary solution will be to add more court time, which means more judge time, more clerk time. I will mention that as part of the ARPA funding request, we have requested a 6/10 of a court commissioner with an accompanying court clerk to allow us to move some more calendars that we now have appearing in person, allow them to be done remotely so that they don't take up courtroom space, and we could add some more calendars that would require court space and perhaps get more juries going. So that would be the hope, is one of the ways we could begin to draw down the backlog. But we continue to look at that and work on it. And luckily for us, Frankie is a systems guy and is constantly looking at reports and giving us ideas about what the numbers are showing and the attempts we're making to address those and the impacts they have. As we go forward, we continue to have the same major space needs that we have had for a long time and that have frequently been the subject of my discussions with folks about the need for a new courthouse. Obviously, those space needs haven't gone away. We continue to operate with, no more than 50% of what was previously a previous study indicated was our needed space. We are still at that level. We have no large courtroom with the exception of Chandler, which has a limited term lease. So if we give up the lease on Chandler, we don't have a space to conduct jury trials in a situation in which distancing becomes important. So it's just something to keep in mind. And the deficiencies of the facility we are in now continue to manifest themselves. And just last night, Judge Wilcox had finished a calendar and sent out a note indicating how difficult the ventilation was in one of the courtrooms of Building 3. And that's been an ongoing issue for us over time. And we continue to just report those in, but understand how expensive the fix is for that type of thing. So that's the general background. What I'd like to do now is run through the proposals we have for this year's budget, and feel free, if questions come up, to just ask me and I'll attempt to get an answer, and if not, turn to Frankie. The first request, number one, is a request for additional pro tem time, and this is for the 4 judges. By statute, RCW 3-34-130, district court judges are entitled to 30 days of leave time a year. Under the current budget arrangement, we are funded for 8 days of leave a year. I think in years past it had been 15, and we always worked to try to stay within that budget, even though the statute had indicated that we were entitled to 30 days. My request would be that the commissioners fund the 30 days. I believe the increase would be roughly $35,000. I don't think we will all end up using 30 days of leave. I think, like in years past, there will be a significant return of that amount back to the county. But as representing the other judges, I think I just feel compelled to make the argument that under the statute, that's what they're entitled to. And as presiding judge, I should make that argument on their behalf. So I do think that's important. I will also point out that each one of us, all 4 of us, are active in various parts of our statewide judges association. Commissioner Wool is currently the legislative chair. Judge Meyer was the past president. And I continue to, and Judge Wilcox and I both teach at the State Judicial College and also at other statewide conferences. So we're all active in participating in these things. And when we do, we have to get pro temps to come in and sit for us. So when we're talking about 30 days leave time, it's not 30 days sitting on a beach someplace. It's a lot of it spent doing judicial work in other capacities. Number 2 on the list is an increase in our supply allocation. We're asking for an increase in $7,000, which I think would be a little bit more than double what we currently get by way of supplies. We continue to run short of supplies each year and have to pull money from other funds to help meet our supply needs. And, as we think about this, one, we want to avoid any mid-year adjustment and say, hey, we just ran out of paper for whatever. Although we are doing our best to get rid of paper, we are using electronic documents. I've conducted court here from home. I have a signature pad here, by the way, and with our electronic documents that we do have in PDF form, I've been signing judgment and sentence forms from the House this week and getting them back to the clerks who can get the appropriate forms electronically distributed. So we are really aggressive in attempting to deal with those areas, but there are still issues that come up that leave us wanting on the supply side. Number 3 is our biggest one here, and this, at least on the general fund side. And this is something that we have mentioned to the board in years past, I think 3, maybe 4 times. When doing criminal calendars, many of the folks that we have as criminal defendants are part of the context of the commission of the crime involves either alcohol or drug involvement. And part of the court's condition on release from custody would be non-use of alcohol and or drugs. The ability to monitor compliance with that condition is really important. Now, for some, if it's a first offense, maybe even a second offense, we may be somewhat flexible in going ahead and authorizing their release and hoping that we can count on them to obey our conditions. But for others, there's too great of a public safety risk for us to trust that person to fully comply with the court order. So we need to make sure that it's monitored. As a former president famously said, trust but verify. And we need to do that in certain situations in order to feel comfortable allowing that person to be released from custody. So we do have some means of technology for doing that. One is alcohol monitoring devices. The primary device that sort of stands for the whole area is something called a SCRAM device. It's a alcohol sensing device that people wear on their ankles. That cost is pretty prohibitive for a lot of our folks. 80 to 85% of the criminal defendants in district court have court-appointed counsel, and they do so because they meet the indigency standards of not having necessary resources to hire counsel. That means they also don't have a whole lot of money to spend on getting a scram device if we order them to have a scram device. And a scram device will run upwards of $15 a day for somebody. And if they're going to have it on, say, for 60 days of pretrial or 90 days of pretrial, depending on how long it's going to take for their case to resolve, that's quite expensive. And we find that we may order this to somebody and they say, oh yeah, I'll pay it. And then next thing we know, 2 weeks later, they're in saying, wow, this is so expensive, I can't afford to pay it anymore. We've let them out of jail because they're on the device, and now they're saying, I can't pay it, and what do we do? Just from a human standpoint, it's tough to put them back in jail if all they've done is say they can't afford the thing that's keeping them out of jail. So we're asking the county to come up with money to help us provide these monitoring devices to folks who can't afford them, so that the court doesn't have to consider that in determining whether somebody's going to come out of jail. The benefit to all of us is that it allows us to get people out of jail, reduce the level of folks who are incarcerated. And when we can do that, we're saving jail costs, which are significantly greater than the cost of having somebody have a scram device. Now, a scram device doesn't work for everybody because that's an alcohol device. So it doesn't measure meth use or opioid use or any other drug use. Those come from urinalysis tests. And so the money would also be used to help us fund defendants if we order them to do, for example, 1 UA a week because of this ongoing drug problem, to make sure that they're not using and that we know immediately if they are. So this would give us that flexibility. We do have some history here because in mental health court and veterans court, we've had treatment sales tax money that we use for this purpose. And we've been able to fund both scram devices and UA tests for our participants in those programs without having to be concerned about their inability to pay. And I can just say, as the judge of those two courts, we've been able to get people out of jail so much easier with the confidence that they can immediately go on to one of these devices or into this testing protocol without having to worry about, are they going to have the money to do so? That has been such a significant impact on our ability to get folks out of jail in those two courts, get them back being more productive, attending their classes, meeting their obligations, yet we can maintain for our community that we are doing everything we can to keep the community safe by monitoring their use of alcohol and or drugs. So it is a boon for public safety. It helps us reduce jail costs in the long run. And it's better off for those folks involved in the system because it allows them actually to be in making some positive steps in dealing with their cases rather than to be sitting in jail locked up. So that's the reason we keep bringing this back before the board. We see a real long-term benefit of this and would really urge the board to think seriously about getting in the business of helping us provide these devices to folks who need them in order for us to maintain public safety with them out of jail.
Let me stop you on that one, Judge, because I have questions and my teammates might as well. You guys have anything you wanted to ask?
Well, the only thing I might ask there at this point is it's referenced coming out of the general fund, and I'm wondering why not the treatment sales tax fund? Because that fund is going up pretty well too.
That is, and that's a great question, Commissioner Edwards. The treatment sales tax money applies to those cases involving mental health issues, which makes it a perfect fit for mental health court and veterans court. It does not have a general application. So folks who just had a drug-related problem, for instance, aren't going to qualify under the treatment sales tax for use of those resources. And that's why a general fund application would be important here. We wouldn't use this money necessarily for those folks in mental health court and veterans court. We would continue to lean on the treatment sales tax for that support, but this would help us deal with the rest of the folks on our general probationary calendar or the folks awaiting trial on the criminal side of the house who haven't been admitted into one of those courts.
Go ahead, Robin.
So actually, if we could show that this was a part of an overall treatment program for the folks who would need these devices, then we could pay for it out of treatment sales tax without them having to be in one of our specialty courts. It's possible. I'd want to check with Elizabeth, and it hasn't been through the advisory committee, but it's very possible that we can pay for this with TST money.
If that's the funding source, that's fine by me. We just know what the need is, and
Right.
given the court the opportunity or the ability to not have to listen to defense arguments all the time, which is, my client can't afford this device. How about if you just trust them not to use? Having the opportunity to say, no, we're going to put them on the device. They're not paying for it, so that's not an issue any longer. That would be very helpful.
Yeah, so we can certainly check and see if it's an eligible cost. It's highly likely that it is.
Okay.
Okay, I got a couple of questions. So, is this like an all or nothing kind of thing? Like, I mean, if the board had 300,000 at the end of the day, and this was our top priority, left, and could you make use of $300,000 for this, or is it based on the way that it's contracted and who's going to be eligible? You feel like it really needs to be the full projected amount or nothing?
I'll undercut myself. I'll say we'll take what we can get here.
Okay, it'd be valuable. I mean, still.
Yeah, no, I think that's an excellent question, and it's one that should be asked. We've had nothing further at this point in our mind that can apply to the general application of folks not involved in the therapeutic treatment courts and district courts. So the ability to get any would be helpful. Having some puts us in a position of trying to determine who among the poorest gets this. And, that becomes somewhat of a difficult decision-making process. Sometimes it's just by who's sitting in front of you at the moment, and maybe the next person is the one who actually needed it more. But yeah, those are, we do that all the time in court. We always have to, handle those types of decision-making. So the answer to your question, Commissioner Menser, is if we get some, it's a lot better than not getting any.
Okay, and then my other question's a little more high level. It's just like, when we get to these, I know they're not all the same, but we've got electronic home monitoring, pre-trial, post-trial, we got alcohol monitoring, these different things. I hear chatter, I'll just call it that, between when I meet with pretrial services director, when I meet with the prosecuting attorney, when I meet with public defense, when I meet with the county manager, when I meet with the sheriff. And I guess what I'm asking is I've never had you all in a room to talk about this, and maybe that's something we should do at the JERT meeting or one of these meetings, but I just kind of want to make sure that, that like, okay, I grant this, but 2 or 3 of my other, elected officials had a different vision, or it's, they're going to make an overlapping request, because maybe Mary Ann wants to do more of this, or maybe the jail had an idea of doing it in a different way. I'm just wondering, is there coordination from your perspective, or do you think that your request is in line with kind of the vision, or is this something that maybe needs another, a coordinated conversation, if you know?
What I'd say to that is I am aware that there have been coordinated conversations going on, and my concern for this year's budget briefing is that we're not there yet. I haven't heard or seen a plan put on the table that will be before the commission this year saying, let's come up with this money to fund this. You know, as I said, we've made this proposal for 3 or 4 years running now. We know how this goes. We've been using money from treatment sales tax to do this. So I know right away the impact it will have. So if we get this now and the county comes up with a more comprehensive plan, for instance, that has UAs being done, and I'm just throwing this out there, all through drug court, whether you're a drug court participant or not, you can refer somebody over to drug court for their UAs, and, we'd have to expand the resources available there, that sort of thing. I'm fine with that. That makes a lot of sense. But to wait to get that program going just means it's going to be another year that we continue to deal with this issue of folks who need this, and the inability to apply it means we're keeping more people in jail than we need to. And so right now, if we had the money, we would just be paying bills with certain vendors and they would go out and do it. And if the county comes up with a different approach to do UAs and run the screening devices through the county, great. I have no objection to that whatsoever. But I just think we don't want to continue waiting here.
Okay, got it. Commissioner Edwards, you have your hand.
I'd just ask you, Judge, do you have any idea how many that could keep out of jail if we were to pass that through to you now instead of maybe setting something up with Mary Ann or whomever? Do you have a rough idea?
Thank you, Commissioner Edwards. I'm going to ask Frankie that question. He developed a 650,000 number. Frankie, do you have a person count that we could apply to that?
So there isn't necessarily a person count that we can apply to each of these situations that would keep somebody out of custody, because each of those is a determination individualized by the judge in the court. So there's no way of necessarily tracking which one would have gone into custody or which one we, as Judge Buckley put it, would trust on the conditions of release. So the numbers provided were based off of all of those in prior years that have been actually assigned the blood alcohol monitoring device, the SCRAM unit. That's where we pulled the numbers from, just because there isn't any statistics that can be kept on that level of detail.
So if that number has been generated just from people that the judges have said, okay, you can get out if you have this device, I can tell you that occasionally we will not even authorize that device if the person has said, I can't afford it. So it won't even be on the order form anyway. So the number could be higher than the numbers of folks who have previously been authorized it. And the folks who have previously been authorized it frequently come back in and say, I can no longer afford it. Maybe they'll pay for it for a week or 2 weeks or 3 weeks to get out of jail. Their family will do it. And then they come back to us and say, I can't afford it. And they've been clean the whole time because we've been getting the results of it. They've been out of jail for 3 weeks now. And then it puts the court in the position of having to decide, okay, do I put them back in because they can't afford the device that allowed me to feel comfortable letting them out? Or have their 3 weeks of sobriety proven that I can trust them on the outside? And that's a really difficult assessment to make. So being able to do it up front is obviously the best way to go. I think it's an excellent question, Commissioner Edwards. I don't know how many people. I can tell you, though, this occurs all the time. We're ordering these devices frequently, and the ability for somebody to get on that device to get out of jail occurs regularly. It's not a one in a week type of thing. It's way more frequent than that.
I think the board probably agrees with you to try to do whatever we can to reduce jail population. So where that takes us, at this point, but I don't think you're going to face a lot of restrictions.
I got Ramiro, then Robin.
Your Honor, and you are correct. This conversation about this tool has been ended, for the last 2-3 years, and I believe there is a need system-wide, including district court and any other of the partners associated with the law and justice system. So if the board considered this request to fund this tool, would an option be just to have the board set aside this money somewhere else so the system as a whole can access this tool as opposed to assign directly to district court.
I have no problem with that. We'll be the biggest user of it, I guarantee you that. But yeah, as I mentioned to Commissioner Mentzer, having something is a lot better than having nothing. I don't need control over the money. We don't need control over the money. We just need the resource.
Thank you.
Robin Luciak.
My question is back to a number. So how many people were assumed to receive the devices to develop the $650,000?
Frankie?
So that was based off of 2019 numbers. We had 315 individuals in predisposition matters and 173 in post-disposition matters. And what it takes is each of those with the $100 initial installation and then the approximated $13.50 per day, which, as Judge Buckley said, can be up to $15 based off of the contractor.
Right. So just under 500 people could be served at this price, roughly.
Correct.
Right.
Okay, let's keep going then.
Okay, next request is for some training, which we've let slide a little bit. We'd like to get our staff participating more in some statewide training. So we're asking for $3,500 to improve our training for staff, and this would give us, by our calculation, we could get 8 staff to in-state training and 3 staff to some out-of-state training with that amount of money. The next one would be a repairs and maintenance issue, and asking for $3,500 to increase in our repairs and maintenance budget. One example of this would be scanners. Our scanners are getting old. We use them all the time now, of course, because we're trying to, we've created all electronic files, so the scanners are burning full time in order to take the paper that comes in from various sources and turn it into electronic file work. So we need to keep our scanners updated. And then, as I mentioned, we're heavily reliant on virtual courts these days, and that involves lots of equipment. Occasionally we need to add cameras, adjust cameras, make some adjustments to the monitors, those sorts of things, and having the ability to increase repair and maintenance fund will help us to continue doing those virtual hearings, which I think are going to be important for years as we work our way through the backlog so that we can concentrate on some types of proceedings in court and others just virtually. And then priority number 8 is the interpreter and coordinator services. And I want to make note that this is coming in under a district court budget request. This position would serve both district court and superior court. And the idea here is it would be one person, a Spanish speaker, who is a certified interpreter through the state, who would also not only serve as an interpreter in judicial proceedings, but would also coordinate the arrangement for other interpreters, not only Spanish interpreters, but all the different language interpreters we use. Right now, those duties have to be split among various staff members to be coordinating with interpreters. We run one full calendar a week for interpreters, and that we call it the international calendar. And there's a wide range of interpreters that are needed to serve the folks who come before the court, and just the logistical work to arrange their presence is a lot. I will say this is one area that has been really benefiting from our ability to go virtual, because we're finding it much easier now to find interpreters when they can appear from Seattle or Portland or elsewhere in a language which may not be common for interpreters in our local area. So it's been really beneficial having the ability to do these virtual hearings. But having one person who would coordinate these proceedings for both Superior Court and District Court, and it would be located in District Court with a MOU from Superior Court. So that would be a big enhancement for what we do.
I just wanted to say a comment on this. This has been in the works for a long time. I know that when the court improvement study was done, this was one of the things that they suggested for both district and superior court. I think it can actually end up saving us money as well, because there are times when an interpreter is used at district court, and then an interpreter is also used at superior court, but there's like kind of no coordination, so we're paying, twice. Well, this person could easily coordinate between the three courts. I feel like in the long run, it would end up saving us money.
And that's exactly right. Thank you, Commissioner Mejia. We get our own interpreters, Superior Court gets their own interpreters, and there's been more than one occasion where we're finding when we try to contact somebody, they say, oh, I'm already contracted that day for, Superior Court. And probably they find the same thing when they're looking for somebody. So having somebody sort of coordinate these would be very helpful.
I would just throw in that, I don't know if we can fund it, but I mean, I'm interested in it. I think it's a non-obvious strategy to enhance the diversity, equity, inclusion goals that we have as a county, making people to come to court feel like, somebody should be able to come to court and not feel like they're an extra burden or an extra hassle, and that's you worry, like, that stresses that person out. They're worried that the judge, because they're obviously getting this extra accommodation, they're worried, is that gonna annoy the judges or the lawyers, and I'm not gonna get treated fairly. The anxiety level and just having a system in place that really treats people consistently and fairly is really important. So I do think that we could improve on this. Go ahead, Commissioner Edwards.
Would there be a possibility that this could fit under Mary Ann's shop for a multiple use, because she's dealing with folks that probably need that service as well, and let her coordinate it? Being it's going to be district and superior court, and what's wrong with keeping track of people that need that service?
Well,
Just a suggestion.
The thing with that is, it also includes family juvenile court as well. And it also includes meetings the courts also coordinate the meetings with attorneys too. Sometimes when an attorney needs to meet, so there's a lot of coordination that goes into it. And I'm not sure if it specifically falls under pretrial services and what their services are. Judge, do you have anything to?
Do you have any response to Commissioner Edwards' idea, Judge?
Well, I think Commissioner Mejia hit on that. It's more expansive than pretrial services. It's not just criminal-related interpreter services. So it could be something else, but to wrap pretrial services in, if they have need for an interpreter to coordinate with the interpreter coordinator, I don't see any issue with that. I think, it would be a good countywide resource.
Okay, well, that's an interesting thing to think about. You have a few others that are, TST's next, great.
Yeah, so that runs the gamut there of our general fund requests. We have two treatment sales tax fund requests, which are each one significant. The first one would be to fund what we call a mental health case coordinator. We have one right now that is a probation officer who specializes solely in mental health related cases. And that's been a big plus for our probation office to have one person doing what we call intensive supervision with these folks, and somebody who really understands the field and can work with these folks to make them more likely to be successful while on their probationary program. So we are proposing that we add another person to our non-mental health court and veterans court staff, our probation staff that handles the general criminal calendar, dealing with folks who have mental health needs. And as we all know, an increasing, whether we're more aware of it or somehow it's increasing, I can't answer that question, but an increasing number of folks in the criminal calendars have significant mental health needs. And we're going to be more successful in dealing with them on a probationary standpoint if we can have somebody who's skilled in that area. So that would be one request. And the other request would be for an additional care coordinator for our mental health court and veterans court. I do think it's important to note that that request for the care coordinator for mental health court and veterans court would not start until 2023. And the reason for that is right now our numbers are down in those two courts, and they're down because of the pandemic. A lot of things just ground to a halt, and we weren't getting referrals from law enforcement, from attorneys, from other folks. And with Keith Meyer coming on board now as our new manager, Keith's been very aggressive in trying to restart that pipeline to get folks re-referred to the courts, and those numbers are starting to pick up. But certainly within a year, we'll be right back up at our maximum capacity level. And having an additional care coordinator. And we originally started with 3 care coordinators when we started these courts many years ago. Coming back up to that level would be very helpful because of the great work these folks do. That's what makes these courts successful. So that concludes district court's requests. And I'm sure nobody else is making any requests, so.
I think we got a couple questions on the TST piece. Start with
Sure.
then Commissioner Edwards, and I got one, and go around the horn.
Here, Your Honor, the per number 1 of the TST, I see the report from the TST Advisory Committee,
Yes.
and I don't know if I'm reading the wrong line, but recommend not to be funded.
Correct.
Okay, so your suggestion is for the board to reconsider their recommendation.
That is. And the reason I say that is because I think there is, maybe we haven't done a good enough job advising the Treatment Sales Tax Board about this. Because it's a general probationary position and not a position solely dedicated to mental health court and treatment court, I suspect that there is a sort of a disconnect in the focus of the service provided by this position. This position would work solely with folks with mental health needs, even though they may not, for whatever reason, maybe they chose not to come into mental health court or veterans court. Maybe they didn't qualify. Maybe the prosecutor said, no, it's not an appropriate means for them, because the prosecutors do have veto power over that. But they still fall into the probationary caseload, and having them supervised by somebody who's skilled in working in that area greatly enhances the opportunities for success for that person, for the rest of us who are counting on that probation to make the community more safe. So I think because it used to be called an intensive probation supervision person, I think because the way it was titled, there was probably some reluctance to consider it a solely mental health related person. That would be my explanation for why they've not recommended it, but I strongly believe that it's an important add-on for our ability to deal with folks with mental health issues.
Thank you.
Commissioner Edwards.
I'll just bump back to that $650,000 that sounds like we're receptive to putting it somewhere to solve a problem. But you folks haven't maybe coordinated that with the rest of your criminal justice partners yet as to where that might fit. But I think so many of the folks that we're talking about here, whether we're trying to keep them out of jail or off drugs or away from alcohol, those people that are pretrial, for an example, with pretrial services, they're going to be the same people that are post-trial before too long. Some are going to get probation or whatever, and some are going to get some kind of a sentence. I guess on several of these positions that you're advocating for, which I agree with, I don't see why it doesn't make more sense to have people from I'm going to use pretrial. Sounds like I'm advocating for pretrial. I'm advocating for efficiencies. why we wouldn't want to put some of this revenue into the pretrial end of things, because they're going to deal with the same people after the trial. So, yeah, and those people that are treated by a caseworker, a probation officer, I don't know what you want to refer to them as, pre-sentence are going to be the same ones post-sentence. And rather than learn a whole new system and everything, I would think it would be better for the person being monitored and for those doing the monitoring to have some consistency as this thing moves through, as these people move through the system. So I'm kind of wondering where our law and justice coordinator could fit in here to put that together somehow. So I don't
So
know.
I do have a thought on that, Commissioner Edwards.
Okay.
And you can ask Mary Ann when she pops on this afternoon, but there's a distinction between the pretrial services, what they are monitoring, and what the care coordinators for mental health court, veterans court, and the mental health case coordinator for probation do. And that is, those latter two are both pre or post disposition. That is, the defendant has already pled guilty and been found guilty and sentenced, and they have sentence obligations. The pretrial cases don't have sentence obligations, they have release conditions. And by law, the release conditions cannot be as expansive as the sentence conditions. So I, as a judge, can't impose treatment obligations on somebody pretrial, but I can post-trial. And that's what's being monitored by the care coordinators and the mental health case coordinator, is they're monitoring those treatment opportunities post-trial or post-plea. So they have many more obligations, and that's really where the coordination with the defendant occurs. Pre-trial, we're just trying to make sure that people comply with the basic requirements that the court has set forth for their release from custody, which tend to be don't use, stay out of trouble, and maybe stay away from a certain area or stay away from a certain person. But they don't include what are you doing for treatment, you know, the various things that a probation officer would get involved with.
I agree with you 100%, I realize that, but I still think just the mere fact that the personalities and whatnot could mesh a little better had that person been already seeing an individual with the lesser restrictions. And then the post-sentence would, okay, we got a little stricter process here now. I think rather than have it separated out in so many different divisions, I just see that it's got a possibility of being more effective in the long run. So that's kind of where I'm coming from.
All right.
And I want to keep people out of jail. I think Commissioner Menser and I, we don't agree very much, but I think we do agree quite a bit on trying to lessen the jail population, cut down on exposure, litigation, budget, whatever. I think we're all there, maybe for different reasons, but I think we're actually there for the same reasons, if I had to guess. I think there's quite a few of these proposals that you've made that I agree with, but I think it might work out better because I think it could serve other sections of the criminal justice family as well. So I'm with you, just kind of trying to figure out how to make it all fit.
Okay, thank you. We're out of time. Great conversation. Thank you, Judge. Thank you, Frankie. We'll have a lot to chew on as we go through the deliberations, and if we have any follow-up questions, we'll be sure to reach out.
Very good. Thank you all for your time. Much appreciated.
All right.
Thank you.
We got 3 minutes to deal with the prosecutor. He's already ready. I see him.
We can keep going, I don't care, whatever you want to
Nobody wants
do.
to stretch their legs.
No, we don't want to keep going, I can see you.
Well, no, I don't.
We want to take a break.
Heads up, I will be excusing myself at 4. Okay, we're back. It's 2:31. Picking up with the Prosecuting Attorney's Office presentation for our budget work session for October 8th, 2021. And we've got 45 minutes for the prosecutor and then a break and then 45 minutes for public defense. Turning it straight over to our prosecuting attorney, John Thunheim. Good afternoon, sir.
Good afternoon, commissioners. So in terms of PowerPoint, is that something that I should share my screen and drive the PowerPoint? Okay.
Sounds good.
All right, let me get to that here. So if I've done this right, you should see the first slide of my slide deck. Okay,
You did.
good enough. Good enough. My intention today is to just kind of do a high level overview. I do want to talk a little bit about budget strategy coming into this, not just what we're asking for, but why and what the strategy is that we are putting behind some of these requests. Understanding that as came up in the prior conversation you had with the district court, and I was watching that closely, that I think there may be opportunities for the board to be looking at cross-system features, for lack of a better word, as resources that could be applied cross-system. And so I'm totally open to those conversations and ideas as well. So let me dig in. And like I said, I'm going to kind of do just a very quick flyover because I really want to see if you have questions or additional thoughts or things that you need me to do, information that you need me to get for you. This is a mission statement that lays out to you our multi-mission, criminal and civil. There's nothing really new or surprising there. Our mission has remained consistent. In terms of our managed funds, this basically just goes through all of the data that was asked for as part of our budget proposal, recognizing that we have a general fund request along with we have a victim advocate program that's funded out of the Victim Advocate Fund. And I think you're all pretty familiar with that. We draw treatment sales tax money that funds part of our programming, primarily focused on the therapeutic courts. And then part of our budget also comes from the interlocal drug fund, in that we house one of the staff members of that unit in our office in terms of a organizational place for an employee for that unit. And then the anti-profiteering fund, which is it's a specialized fund that has a small amount of money that's restricted to doing anti-profiteering, or what sometimes are called RICO type investigations or cases. Our challenges probably are going to look very similar to the challenges that you're seeing across the criminal justice system. Number one being resources, and particularly COVID impact on resources. And that's where I'll spend a good amount of my time when I get into the requests, in terms of I want to make sure you all understand our strategic approach to what we're dealing with in terms of the COVID impact. And that is not only dealing with backlogs, but just operational things as well. Outside of that, we continue to grapple with the same issues that we always have grappled with, and these are nothing new. Substance use disorders, including alcohol and drugs, mental illness, child abuse, domestic violence. All of these are the issues that we are constantly facing day in and day out in our criminal division in particular. I do want to note, though, that involuntary treatment is continuing to be on the rise. And we have a full-time deputy doing involuntary treatment now, and that's starting to even expand beyond that, given the addition of mental health beds in this county. And I expect that to continue even more over time, particularly over this budget time. And so that's just, I think that's an awareness thing. We're not making any requests on that at this point, because those are generally funded through contracts with the BHA, whatever it is called now. And then the other big thing that's been happening over the last 3 years that I know you're also aware of is public records. The number of requests, the litigations that are coming in, and we are going to be asking for some additional help for our public records unit, given the substantial increase in workload since that was formed 3 years ago now. Okay, so on policy level request 1, this is a capacity addition to the criminal division. Now, here's what I want to make clear, and that is that at the time we were submitting budget proposals, the issue of whether recovery funds could be used for the backlog, to address the backlog, was still undetermined, right? And so I submitted proposals for both general fund and for Recovery Act. Those are not intended to be one on top of each other or consecutive to each other, however you want to frame it. Those were designed to give you a choice in terms of general fund or recovery fund, because we just didn't know at the time what direction the board would want to go with that. So I just want to be clear that this is not intended to be duplication on top of Recovery Act. The bottom line here is that what we're looking for is criminal division capacity to start to address the backlog of cases that have built up. And let me just take a minute and be clear of what I'm talking about there, and then share with you the strategy that I have in mind to try to address that, and then how this capacity plays into that, how these FTEs play into that. As you heard a couple weeks ago or thereabouts when we had our backlog meeting, when you were hearing from everybody, there's kind of 2 different backlogs in play here, depending on your viewpoint. One is in the court itself. That's the cases that have been flowing in that haven't been able to get resolved because trials stopped or slowed down. And so these cases have been building up over time in the system. They're filed. And they are active cases, and they right now are assigned to deputy prosecutors. The way that, because our priority and our focus has been solely on those cases, that's right now the capacity of my criminal division is completely focused on that portion of the backlog. All of my deputy prosecutors are at or exceeding capacity in terms of their caseload of active cases right now because of that buildup. What I'm really looking at Recovery Act money for is to try to look at the other backlog that is there, and that is the pre-filing backlog. And that's the one you've heard about where we gave you some numbers a couple weeks ago that is around 1,800 referrals in the felony division of the office, the felony part of the office, that haven't yet been screened or looked at because we just haven't had the capacity to do it. And that's one of my primary messages to you today, is that I don't have enough capacity to actually even start to look at that, because everything I have right now is consumed in just basically managing and monitoring everything that's going on those cases that are already filed and moved. And so that's why that backlog is continuing to grow over time. What I'm looking at strategically for these new FTEs is to start doing that, to start looking at that backlog and start addressing those unfiled cases. But they still have victims out there that are looking to have some response from the system taking to those cases. In fact, the number of calls and concerns and questions from victims has really been growing astronomically over the last couple of months because of those cases building up. To do that, I've got a couple of things planned. One is we will be using the first look strategy to do that. And that is that as soon as one of these new lawyers picks up a case that isn't filed yet, obviously the first thing they're going to do is determine whether it is actually a chargeable case. And if it is, then the next question that they'll be asking is there a diversion opportunity here for this particular case? Does it qualify for diversion? If so, what kind of diversion? And they'll start working on whether that case could be diverted into a program even before the case is filed. And that's really something culturally new for our office, because generally cases didn't start until the charge was filed. And that's when we would start working the case. The whole first look philosophy is actually about working the case from the moment that we pick up the case and take the first look at it. That's where that name literally came from, first look, right? And so those lawyers will be working on that body of cases to try to filter cases out of that backlog that can be filtered out in terms of a diversion. And perhaps even if there needs to be a charge filed to get it into a diversion, like the drug court or a therapeutic court, they could file the charge, but they could get it diverted even before the arraignment, which would be the very first court hearing that would generally happen. So the whole point of this is to try to maximize the use of that time before the person is arraigned to see if we can get the case resolved. My thought is, if I can get those cases out of the system pre-arraignment, then those are less cases going into the system beyond arraignment. Those are less cases that actually need the full processing of the criminal justice system. And it'll reduce the impact on the full system then from that backlog. So the proposal I have in front of you for lawyers and staff and investigators is to attack that backlog. And basically, whatever you decide is the appropriate and affordable amount that you could put into that you can invest into that, all that does is determine how quickly and how much I can dig into that backlog. And that part I'm absolutely open to talking about. In fact, Romero and I had this conversation the other day about, as we start up, maybe we ramp up over time. The budget request you have here is obviously for the entire budget cycle, but maybe there's a ramp up we do here. I'm open to that conversation. My priority is just that I need to get something additional to get started on that pre-filed backlog. And the need for investigators, I just want to take a little, or an investigator, I want to take a little time to just emphasize that, because the other issue is these cases have been sitting for a while, as you know. And for me to go back now to law enforcement, or one of my deputies go back to law enforcement and say, hey, can you go back and locate this witness or this victim from this case that you investigated 6 months ago, 9 months ago? That's just not going to happen. They have other things on their plate now. And so I need some resource to be able to do that and to freshen up those cases. So that's why I'm trying to create this balance of deputies, staff, investigators. And so that's what that proposal is about. And if we are able to accomplish that using Recovery Act money, great. Then this general fund proposal doesn't need to be further considered. Again, this was all about giving you a choice between using general fund or recovery funds.
Before you move on, John, Ramiro had a comment.
Hey, John.
Great.
You're right. You and I had a discussion about this on Monday. And I mentioned to you that the board authorized the release of $1 million out of the ARP funds, out of the set aside of the overall backlog number. And the board released, just to start working system-wide, how we can start working through the backlog. So you should have in your email a request to have a meeting here in the next couple of weeks. So with all the partners, have a conversation as to how we can start moving the backlog along and see how far the $1 million will take us. And depending on the rate of addressing and assessing the backlog cases, they will provide the board with an update to see how they're going to be releasing the additional funds as we move along. So that is in the works, and hopefully we can have a meeting here set up in the next couple of weeks.
Yeah, I did see that email, Romero, and I appreciate it. I knew exactly what it was. and that's why I wanted to make sure I made the comments today that to me, this is, the source of the funding doesn't matter. It's kind of like where district court was between TST and general fund. I just need the help. That's what I need, one way or the other. The second one is about the addition of eProsecutor, which we went live with a couple of weeks ago. And so far it is functioning well. Any go live process has its hiccups and bumps, and we've been doing that and problem solving. But overall, I have to say that that my team is very enthusiastic about this and working on it. But what I need long term is somebody who can really continue to manage this system now. It's and not just, I'm not talking about software technical stuff. What I'm talking about is the workflows and the screens and things that are built into the system that falls on us to continue to develop those. And so I want to try to get a position that is dedicated to just that function to continue to maximize the use of this eProsecutor as a tool. We already have somebody working in a temporary position that way. It was a temporary promote that helped develop us to get us to go live as we were building this. And so really this is now a request to continue that into the future as an additional position to our FTE count. The third one is intended to be a conversation starter. This is maybe a little bit like District Court's EHM proposal, but admittedly earlier. And this is the first time I've asked for this, but it has a role, again, relating back to the COVID recovery strategy that I've been talking about. What I asked for was simply basically a placeholder. And this is an estimate only of $100,000 to create and look at and implement a diversion program, prosecutor-led diversion program that is would not otherwise qualify for TST. This could be the kind of thing that was, I think, talked about by Romero in the prior presentation, where really I'm just looking for a placeholder on some funding to be able to go to work and build something and then bring it back and say, here it is, and then we've got a funding placeholder for it, however that exists in the budget. And here's the strategic role that this plays in what I'm talking about. As I said, when we attack this backlog of unfiled cases, what we'll be looking at is diversion, pre-filing diversion opportunities, or perhaps even some pre-arraignment opportunities for charged cases. But some of those cases won't be qualified for TST services. And right now, the pre-charge program that we have in pretrial services and the post-charge diversion, as I understand it, are TST funded. And so it restricts the cases that we can put into that program to those that are diagnosed SUD and or mental health or co-occurring, something like that. But we get a lot of cases, in particularly first offender cases, where we just want to divert them out, have them pay their restitution, do some monitoring. Perhaps there's some education work that they can do or community service work that they can do, whatever that is. And then if they are able to accomplish that and stay crime-free for a period of time, case goes away. We've been doing that for 3 decades in this county with an organization called Friendship, which is a nonprofit organization. But here's the latest issue that has come up predominantly in the criminal justice reform arena. That has been a defendant pay program, right? It's a private nonprofit. Friendship is a nonprofit, so they don't make money. And the only way they operate is that the defendant pays a fee to engage in that. Problem is, as Judge Buckley was talking about with EHM, that might be prohibitive for folks who can't afford it. And that's been the biggest criticism of that kind of diversion program, that defendant pay diversion program, is that it starts to designate people or qualify people based on how much money they have or what their income is. And I'd like to get away from that as a criteria and have a diversion opportunity for those who can't afford it, but they don't qualify for TST. That's my goal. How we get there, that's the part I want to talk about. What's the pathway to get there? We can talk about that and how much it would cost. Again, that I think is a discussion. What I wanted to do here was to get some kind of a placeholder in the budget for this for development purposes, and frankly, to start the conversation and get the ball rolling, if you will, in order to try to get this online as soon as possible so that I can use this as we're going through backlog cases. And priority 4 request is a victim advocate position. A couple of things are happening in our victim advocate arena right now that I want you to be aware of. One is the state reduced its funding support for victim advocacy in what we call general crimes through the program that is called Crime Victim Advocacy Network, which is housed in our office. And so we actually were reduced a victim advocate position from that reduction. The other thing that's starting to happen is based on Blake to start with now a reduction in the number of drug cases that'll be filed now and into the future, and an increase in the number of cases that get diverted pre-conviction. The money that supports that program is, I think over time is going to start to deteriorate because our victim advocacy program in this county is solely funded by, again, defendant pay legal financial obligations. The county has rarely invested in victim advocacy services because they didn't have to, right? Because we had this fund. I actually think there might be some legislative action on that this session that would change the landscape on this. But up until this point, we've now lost a victim advocate, and we're seeking to have that restored to keep our advocacy program intact. That we maybe could talk about how that also interacts with the COVID strategy and the Recovery Act proposal as well. Let me see here. Next one. And then finally, the public records unit. The workload in our unit since its inception 3 years ago has increased by 76% in terms of the number of requests, the number of service requests coming into that unit. What's ended up happening now is that the paralegal that's in that unit has been overwhelmed. The lawyer has had to divert time to support that work, and that has taken away from the time of the lawyer to support the departments on training, other legal issues, the other things that unit was designed to do. And so we're asking to add another staff support person to that unit to continue to help process all of these requests. And then the last thing is simply to do an adjustment in our budget to recognize the increase in the rents that we pay as part of being part of Monarch's Children's Justice and Advocacy Center and the Family Justice Center over at the Family Support Center. Those are minor adjustments, very small amounts of money, but it would bring our budget in line with what the actual rent is. We've just been absorbing those increases over time. So that is really a request that is an adjustment to make the budget match the reality at this point. Those are the requests, and I'd love to hear questions or thoughts or additional comments.
Maybe Robin, can you explain the first two there?
Yeah, the part of the prosecutor's office is funded by treatment sales tax, and the prosecuting attorneys started to track the time that they spend on these cases, and the way I'm reading this request is they're finding that there is more time that the attorneys could build a TST. So this reduces the general fund appropriation and increases the treatment sales tax appropriation to accurately reflect where the time is spent and charged. Is that an accurate statement?
That sounds right to me. That to me was more of a, a shift in the where the money is coming from.
Right.
But if that's what the numbers support, I'm fine with that. And I will just say that could shift even more again as we're digging into this backlog, because there might be cases that go into drug court that then would start drawing TST funding to support that as well. So that number could even shift more over the next year as we do backlog work.
Right.
And that is included on the TST advisory committee recommendations.
Okay.
And that makes sense from your perspective.
It
right?
absolutely does make sense from a cost allocation purpose, yeah.
And on that perspective, John, I know that we've had conversations about this for the last 3 years, so I really appreciate you making an effort on this, so much appreciated.
Right, the time tracking, it truly, as you can see, it really pays off.
Questions for prosecutor? Commissioner Edwards is good. Commissioner Mejia is good. Looks like I'm good. I think I understand.
Oh my goodness.
Oh, I'm sorry. I'm sorry,
No.
John.
Straightforward.
I did have a question on your victims advocate one.
Yes. Okay. I was going to say, I was actually hoping to get some questions because, I like to talk about this stuff.
You did a great, no, I mean, honestly, you did a great job of explaining, like, I had a lot of questions coming in and you basically answered them with your explanation, so thank you.
Great.
But the victims advocate, I guess I still need a little bit of a sense of like, the overall scope, like how many did you have in a perfect world and how many are left? And you said you lost one, but I don't know, like you lost 1 out of 6 or 1 out of 2 or, and then you said, state money had been reduced, what percentage was paid by state money, kind of where, a little more
Yeah.
detail on that in terms of where we were and where we are now.
Okay. So what I do know is that we have the funding for this is divided up. So that's one thing to understand. The state money funds in CVAN is funding only what they call general crimes. So I can't cross over and use that money for what we would call special victims or domestic violence, which is in their world, basically sexual assault or domestic violence. And so that's restricted funding. I lost one of those positions. So I'm down one victim advocate there. And then we reduced a victim advocate during the budget cuts 2 years ago. As we zeroed it out, basically, is my understanding, to be able to match the amount that was requested for our cut. But let me say this, it would be better if I followed up with an email that gave you more very specific information about the number of advocates, exactly which positions we reduced and what they're attached to. And I think that would be a better way for me to answer that question. I'm happy to do that, really quickly.
Okay, sounds good. Then I guess anybody else? Robert's got some.
On the victim advocate fund, I don't mean to get into the weeds, but I'm looking at the financial plan. And it's my understanding that one of the grants that we've been anticipating is not gonna come through. So,
Well, that's the position that I'm talking about. So
okay.
the grant itself remains intact, as I understand it, but they've reduced the amount of the grant by an FTE. So
All right.
we will be short. We're going down an FTE, and that's the one that we're looking at.
Okay, great. So more information coming on that.
Okay.
Thank you.
Yeah.
Okay, very good. Thank you, John. Appreciate it.
Thank you. Appreciate the time. And if there is follow-up, please don't hesitate to reach out and ask.
You bet. We will.
Thank you, John.
Yeah.
So we're on a break till 3:30, where we pick up with public defense.
Yep. All right.
And I did want to ask
You're on, Commissioner.
Okay, we are back. Okay, we're back. It's 3:30 p.m. We're picking up with public defense, our final session for this whole week of budget presentations. It's Friday, October 8th, 2021, and we've got 45 minutes. Pat, I'm going to be excusing myself personally at 4 p.m. Commissioner Vice Chair Edwards will close out the meeting. You and I have discussed your proposals a couple of times, so I'll follow up with you with any questions, but I just didn't, no disrespect, I apologize.
Yeah, no, thank you, Commissioner, and good afternoon, everyone. And maybe, depending on how things go, maybe we'll be able to finish by 4 o'clock. So, good afternoon, Patrick O'Connor. I'm the Director of Thurston County Public Defense, and joining me here today is Jose Vargas, Thurston County Public Defense's Fiscal Manager. Jose is here to help if necessary, if the board has any finer details on anything that we're proposing. So I believe I'm driving here, so I will attempt to share my screen and share my presentation. So I'm assuming everybody can see that?
Not yet.
You're above your pay grade, Patrick.
Okay, let me try this one more time. I'm assuming you can see that.
No.
Here it comes.
Okay.
Yep, we got it.
Sorry, I've been living in the Teams environment, so you're taking me way back to yesteryear with Zoom.
Tomorrow.
Just kidding. I guess there's a whole category of virtual meeting jokes that are going around. I'll try to keep the time in mind for as much questions as possible. I'll keep this slide up for a second, but obviously us at the Public Defender's Office, we serve our community in a variety of different ways, mostly stemming from protecting our communities accused that their constitutional rights if they cannot afford counsel, in addition to civil representations that are listed in this slide. So briefly touch on, obviously, the funds that we manage here at Thurston County Public Defense. We are principally, of course, general fund funded. We also receive treatment sales tax funds as well as this slide demonstrates. We have from 2020 to 2021, as you can see specifically in the FTEs, you'll notice an increase there of 3 general fund FTEs from last year to this year. Those specific 3 FTEs have to do with the Supreme Court decisions in State v. Blake. So we have 2 full-time defense attorneys doing exclusively Blake work and 1 legal assistant that's now exclusively doing Blake work. And I'll touch upon that in a little bit of our challenges. But all in all, nothing too big to lift up here unless the board has any specific questions.
Nope.
Okay, hearing none, I'll move to the next slide. I was joking earlier this morning with Jose that I probably could, and not our office, but probably most offices and departments probably could put together several slides on challenges in 2020, but I just wanted to highlight a few. Obviously, the COVID impact on public defense and the criminal justice system that the board's fully aware of has been, frankly, very, very challenging. Specifically to public defense, it's been the impact on staff, not just the attorneys, although the workloads of our public defenders has certainly been an incredible challenge to them. But it's also been an incredible challenge to our professional staff, our legal assistants, our paralegals, our investigator, our fiscal and administrative team that Jose leads. There really isn't one aspect of the department that hasn't been challenged by the pandemic. Specific to public defense and attorney workloads is the balance between the amount of cases that they're representing and how many clients they can have in a non-pandemic year compared to what they've experienced in the pandemic. And actually, our Washington State Bar Association's Council on Public Defense spoke to this unique challenge in an advisory opinion, and I've shared the details of that in the body of the request, actually. But just to highlight the basics, a public defender can, in any normal non-pandemic year, only accept up to a certain amount of client representations before they become per se ineffective because they're just representing too many clients to do a good job. The pandemic has certainly presented a lot of complications to that. So adjustments have had to be made, and recommendations statewide for folks like myself that are directors and managing attorneys for public defenders have had to figure out what is a pandemic caseload. We know things are certainly taking longer, that there are challenges with virtual hearings and general communication, and then given the suspension of jury trials, that cases are taking longer to resolve. So therefore, their caseloads aren't resolving and staying, resolving at the same pace as they would in a normal environment. So, in other words, our attorneys are experiencing massive caseloads because it's just taking longer to get cases resolved. So having to make those adjustments as to what is an ethical caseload has been a challenge for me. I'll just be candid. It's very difficult. It's also been a challenge, of course, for the attorneys and staff, just both in a work-life balance. So we try to take extra care to take care of our people, to retain them and make sure that they're staying healthy. But it's been a challenge, just to be frank. Other impacts, certainly State v. Blake, which I know that that you all are intimately familiar with by now. But the challenge specific to public defense, when that decision came out in February, on top of the challenges of the pandemic and just practicing public defense in the pandemic, was frankly overwhelming and still is, but we're in a much better place now than we were in February. The result of that decision, of course, essentially for my department, created hundreds of new unanticipated clients going into this year, and really specifically unique to public defenders with this decision is, the ethical obligation to represent clients and act on their behalf, and the impacts of that decision, of course, for those that are currently incarcerated and for those who are no longer incarcerated because their cases have been resolved, sort of uniquely fell on our office. And we accepted that challenge with open arms, but with limited arms. And now we, thankfully, and I really appreciate the board's support, have those additional staff to do the work exclusively. They've been doing that work as a team since the beginning of last month. And prior to that, it was a mix of myself and other attorneys in the office trying to get to as many cases as we can. So far, it's been nothing short of what I'd hoped it would be. And they're matching resources on the prosecutor side, which has been incredibly helpful as well. And I think actually both those teams are working really well together. And of course, one other challenge for every office, but I'll speak to our office, has been staff safety. It's been a top priority of mine, obviously, as the leader of this department, to keep our staff to keep our staff safe while doing the work we do, right? Which is specifically for the attorneys working in the jail, working in courtrooms in close contact with clients, and then our professional staff also working in those same environments week to week. I think we thanks to my staff, have done an outstanding job of staying safe, staying diligent, even to today and in the months to come. So been a challenge, but luckily we have been fortunate enough to avoid any major disasters. The other challenge for us has been office space. I'll touch upon it just briefly. Is, as we've grown, space continues to be a premium, and I know the board has recently made a decision on the future of county space. But I've spoken with Romero about this, and we may need to look to a solution in the interim of that project to try to find some additional lease space for office so I can find appropriate workspace for my staff. So I'll move right into the policy level requests and lift up. And of course, please feel free to interrupt me and ask any questions that you have. I'll start with our priority one, which is the request to add a full-time FTE defense attorney 3. That classification is an attorney that's qualified to handle any type of criminal representation in the state of Washington, including the most serious offenses. This is a position, our felony team, this position would reside in our felony team. And this position did reside within our felony team prior to the pandemic. And the prior occupant of that position had retired. And so my request, given the pandemic and the constraints on our current trial attorney's workload, is to add another staff member to that team to help relieve those pressures, those stressors, and meet the demands of our appointments. If does anybody have any questions about that?
And just Pat, because we kind of had a parallel discussion a little bit with the prosecutor, I guess I'll ask, like, my understanding from you of this position is it would help you obviously with backlog, but it's really more about something that you would need post-pandemic, post-backlog. Is that correct? Or is this something where you're trying to address an increased workload on your office because of pandemic?
I would say it's a combination, Commissioner. This position did exist just to meet the normal demands of the appointments from the court to our office prior to the pandemic. The not having that position certainly has amplified the stressors and the management and the caseload management, not having that additional position, especially with the heavier cases, the most serious cases that our office gets appointed. So I see it as not only as a need in a non-pandemic environment, because just based on the normal caseloads that we've experienced, but certainly it's been amplified during the pandemic because, as I sort of hit upon before, we've had to manage due to the advisory opinion by the State Bar Association's Council on Public Defense on what is a caseload in the pandemic for a defender. So we've certainly reduced the caseloads based on all the recommendations and factors there on how challenging it is. So those additional cases that would have gone to a specific trial attorney in a non-pandemic environment to this other position, not having that position makes us look outward to outsource that work, which is something that I think this board is very familiar with, that I have worked very hard on with the assistance and help of Jose and on a whole team to target not letting cases leave our office if we did not have a conflict of interest. So if I don't have a position like this to help manage the pandemic caseload assignments, then I have to look elsewhere to have those representations take place. And I'd much rather have those representations take place here by a supervised, trained, and managed attorney. So I hope that answers your question. It's I would say it's both.
Okay, go ahead, keep going.
Okay. My next priority request is to increase our training budget. Our current annual training budget is a little over $11,000. I have 43 FTEs. And as you can see, our annual Washington State Bar Association dues for 23 attorneys that we have is a little over $10,000. So this is something that I set out as a goal when I was appointed to really make an effort to increase. This is the first time I've asked for it. Part of our strategic planning internally always surrounds professional development, training, et cetera. And we're just limited in what we can do with staff. And it's a constant and should be a constant feedback from our staff of greater opportunities for more professional development and training opportunities. I believe this is a fairly modest request to increase our training budget so I can provide the type of training and professional development, not just to retain staff, but to have them grow and have leadership opportunities here in the department.
Ramiro.
Hey, Patrick, on your PowerPoint, you have the 30,000.
Yes,
But then you have an expenditure amount for 2022, 175,000 for 2022.
that's an error.
Oh, okay, I just want to clarify that.
Yeah, thank you.
Just
from the top.
wondering if we're paying attention.
Yeah, that's from the
Yeah.
line above.
Yeah,
Yeah, you'll see it reflected
Okay.
in
Only
in
line
the,
above.
okay, so.
Yeah.
That's on me. That was my fault.
So not trying to, I just want to clarify, so it's only 30,000.
yeah, it's only 30,000. Thank you.
Yes.
Thank you, Romero. And no, Jose, I'll take that, not put this together. I apologize. It is just a 30,000 increase.
I have a
Robin's got a
about
question.
that. So Patrick, on the training request, one of the things that you've shared with the board is in prior years, you've spent substantially more than what you currently have in the budget for training. What did your office have to do without to be able to buy the training?
I'm sorry, Robin, I couldn't catch the last part.
So, for example, in 2020, you had $11,000 in the budget for training, but you spent $19,000, right?
Correct.
This would,
Right, so for that $8,000, what were you not able to buy because you had to spend it on training? What did your office have to do without?
What did we have to do without? Well, I'll certainly allow Jose to chime in. I'll refer you to our formal request. We've itemized several training opportunities that we would like to offer that we have not been able to offer. There's national trial trainings. There's national trainings that we can't send people to. There's a whole host of one of the methodology here for coming up with this number was to specifically identify several identified trainings that have been asked by staff of myself to fund. And I don't have those to rattle off the top of my head, but I can certainly follow up with the list. So I want the board to know that I didn't just pick a number and throw it out there, that it's tied to very specific trainings that we've identified based on feedback from staff and of course my own input on professional development and training opportunities. So unless Jose knows those off the top of my head, we can certainly follow up with an itemized list.
if you want me to spend, I can answer right now that I cannot recall any specific item that we didn't buy because we spend the money in training, because we actually use money that was targeted and apportioned to other projects, to other objects, such as professional services, salaries, any savings on salaries that we have. So for example, if we had a gap on a position, so we didn't per se buy something that we needed. We took a risk that we could spend the money in the training because we had to. We had to pay the bar dues. We had to pay other training.
I'll just chime in here real quick, Jose. One of the things, of course, that we're obligated to pay for is attorneys are responsible for continuing legal education credits every year to maintain their bar license, and so as a condition of employment. So we do allocate a portion of those other funds to make sure that our attorneys can keep their bar license and attend the continuing legal education series that they need, but not much beyond that.
Right, I'm not suggesting that your folks don't need training or deserve to go to training. I'm just, I guess that part of me is saying that maybe you only need 25,000, not 30, or because if you can't say you had to do without something when you went over your training budget, you're always going to have some staff savings, you're always going to have some kind of savings elsewhere that you could devote to this.
I will certainly follow up with the things that we have done without.
There you go.
And I can tell you, just philosophically, having been in this department a long time, you never asked.
Okay.
I can certainly come up with a list
There
of
you go.
the items.
Fair enough.
Yep, thank you.
Yes, okay. Priority number 3, this is a request to add 1 full-time investigator to the department, bringing our total of in-house staff investigator to 2. The prior board did fund our first investigator back in 2018. Can tell you it has been wildly successful. And so I'm asking the board to fund another position. I would note that, not only is there a demonstrated need because we have 1 investigator to support 23 attorneys, which is insufficient. And our current investigator is only relegated to supporting and investigating a portion of our adult felony cases because he doesn't have the time to support the other juvenile criminal cases and our misdemeanor district court cases, all of which are entitled to. And in fact, the defense attorneys are required ethically to investigate cases. So we continue to outsource that work as well. I'll just remind the board that the standards of indigent defense by the Washington State Bar Association for public defense, particularly in standard 7 of those standards, recommends that there be 1 investigator for every 4 lawyers. So I feel this is a modest ask to take us up to 2 to support 23. And I'm happy to answer any other questions.
I got a question there. So is this, is there going to be a corresponding savings in outsourced public investigator, or is this amount that you've said, is this the net cost, or how does that work in terms of however many cases that your in-house person can do might mean you have a reduction in what you're going to have to outsource?
Yeah, so right now, Commissioner, we're outsourcing all district court investigations and all juvenile investigations. That's a change that we've been working under this year because really of the demand for the 1 investigator services throughout the entire department and really trying to focus his time on our adult felony cases. I can tell you, and we can certainly follow up with the numbers on what the expenses have been that we've had to outsource those investigations. It's not an apples to apples offset of what an FTE cost and expenditure would be. But what I can tell you, what isn't captured, and this is no longer theoretical because of the investment in our investigator in 2018, there is an unquantifiable amount of efficiency and savings to have this work done by somebody that is in our department every day of the week, that's supervised, that we can ensure is getting the work timely done. And, again, some of those benefits are hard to quantify in a dollar amount. But at the same time, we do have some offset of savings. And Jose may have that off the top of his head, maybe not, but we can follow up with that. But I can tell you it's an investment that isn't going to be a sum zero.
Well, and Ramiro's got some, but I just as a comment, I worked, as you know, I worked in a public defender office, and my experience working with, I worked as a contract public defender, and I've worked on an in-house, not in your office, but in Alaska. And I've worked with in-house public investigators, and I've worked with contract investigators. And what you said just a minute ago is like understated, frankly. The efficiency by which I can walk next door to the investigator and say, hey, what's going on with Johnny? Did you get that witness interview? And then I walk back to my office. That literally took 30 seconds. Having to call a contractor, leave a message, call him 3 times, just to get a quick answer. So on one hand, I'm arguing for your position, but on the other hand, I'm thinking like it might be a net positive to the county in terms of a reduction in the number of, I don't know how you're budgeted for your professional services, and whether that can be adjusted or we're going to wait and see. I don't know how that works. Do we wait and see and then make the adjustment? But I can't imagine that the in-house person couldn't do twice as much work just because of efficiencies that you described as having to deal with a whole suite of external contractors.
Yeah, certainly, I would agree with that, Commissioner. And he, our current investigator, has done twice as much work. It's just he comes to a point where he is only one individual, and supporting 23 attorneys with thousands of potential cases becomes unethical. But in terms of efficiencies, like you said, what we've experienced with that investigator is, you're right, we are much more efficient. So could I put a dollar amount on the savings to the county if our in-house investigator is able to run over in the jail in the morning, meet somebody, do an interview, get that information back to the defense attorney, get it to the prosecutor, and the case resolves a month earlier than it might have otherwise? Yes, that happens. Do I track that number and can tell you that saved the county $30,000 every 6 months? I don't have that data to demonstrate that, but it's known, and I'm confident that it's a good investment because I see it happen every day.
Hey, Patrick, along the lines what Commissioner Messer stated, intuitively, and as you said, is you cannot compare apples with oranges. I understand it, but intuitively, but if the board decides to fund this investigator, there's going to be more cases coming in-house than actually going to outside to professional investigators. So intuitively, there has to be some sort of savings.
Yeah.
And
Yes.
which is, I know that I'm going one step ahead on your next request, because your next request is to add professional services for investigators.
Yeah, I'll explain the difference, but and I don't want to let you. I'll let you finish your point, of course.
So intuitively, Commissioner Mesa is right on point, I believe.
Yep.
Because intuitively, you're going to bring some cases in-house if the board approves this new investigator position.
Correct. Yes, and we will have some savings there. You're absolutely right. Is it $107,000 for an FTE's worth of savings? No, it's probably in the ballpark. And I see Jose.
I don't know. I bet it's possible it could. You can't quantify the positive that doesn't happen. I mean,
No,
Yeah,
it's
Well, we
easy to
can-
keep track of the
Yeah, but you're
shit.
gonna save some for not farming out cases.
Yes, correct.
That's all I'm
And
talking about. I'm not talking about the unquantifiable.
Yeah,
I'm
no,
talking
no,
about
right.
the cold, hard numbers.
The reality of it.
If this
Yeah.
guy has 100 cases that would have been farmed out,
That's
then
what-
how much would we have spent on the farming
Because
out?
in a yearly basis, I just going to use a number. You're going to be bringing 100 cases to this in-house investigator. Otherwise, you won't be paying professional services for those 100 cases.
Right.
I guess that intuitively, and I know there's more complicated than that. I get it. But at that level, it should be something.
So it's kind of like we had the long conversation with the sheriff. We've got FTEs and then we've got his overtime budget. And he's asking for more FTEs and more overtime budget. And I was asking, well, wait a minute, if I grant them more FTEs, doesn't that mean it'll be a corresponding reduction in your overtime budget? And this is, to me, is kind of analogous. I mean,
Yeah.
I want to give you this position, but I'm just wondering, should there have been a calculation, and do you have a professional services budget that should have had maybe not a corresponding reduction, but some reduction? It might be 10%, it might be 50%, it might be 120%, I don't know. But I'm just asking, should we calculate some type of reduction like that just to account for the efficiency that we're funding through this extra position?
Yeah, the short answer is yes. There will be a reduction. The dollar amount, Jose, would you happen to know that?
No, there's no way I can know that. And,
Yeah.
I can take an estimate, and to be honest with you, to me, that wouldn't be ethical to do it, because what we're not taking into consideration in this conversation is the fact that we actually have to pay for investigative services for panel attorneys.
Right.
Okay. And the other thing that we're not taking into consideration is that by us adding an investigator, it's going to increase the availability or the opportunities for our attorneys to use an investigator, which otherwise right now they don't, because they rely on Dave, significantly to do that investigation, and he's only has X amount of hours, X amount of time to do the investigators. investigation.
Yeah,
So, I mean, I can come up with a number, but it's going to be an estimate. And to be honest with you, I don't really like to deal with, guessing.
Well, Jose, I can come
That's
up
not
with
what
a
I do
number.
for a living.
It's my job. I'll come up with a number, but it'll be even less based in reality than what you might be able to guesstimate.
Yeah.
But that's my job. So I think
Yeah.
you'd rather give me some input rather than letting me just imagine what that number might be, because I might very much overestimate for the reason, and what you're saying is totally accurate. I was a contract attorney, and a lot of times I did not. I mean, I can tell you, I only went to the contract, it was so cumbersome to do the paperwork and get the approval and deal with the outside investigator that I only did it on the cases I really had to. If I could use one of my paralegals or just do stuff myself, I would just do that because it would be more efficient. The work had to get done, but you're right that just more quality work's gonna get done by having this position. So I 100% agree with you, it's not apples to apples, but there has to be a number. It can't just be nothing because it's hard to compute. Otherwise, you're gonna make me just make it up. And that doesn't seem right. That doesn't seem like the best way either.
Right. And no one is suggesting that we would wipe out the professional services for the
Absolutely not.
External investigators.
And I have to go in a minute, but I do understand that Pat's last request is it's not about additional, it's simply about the rate paid to the people that are already being contracted out with, and that's a different type of request.
Yeah, so what we'll do, Commissioner, is I'll move on to the next one. I know you have to leave. We'll come up with our best estimate as to what cost savings we could identify right now to offset any professional services to fund the position. But I will echo one more point on that, which is what we've seen and what we've experienced, and even as you said, is your own experience. We will get more investigations. And we've seen this with our in-house investigator. We will get more investigations as a result of a fully funded FTE in our department than we are currently receiving because of the access and the systems and the process makes it much smoother and much more efficient to get the work done. But we'll certainly provide that information to the best of our ability and a best estimate, understanding it's just an estimate.
Please understand, I'm doing this in a spirit of wanting to be able to give you this position because it helps us if it's going to cost a little less than 108, that helps us get you there.
We will get you those. We will get you that estimate.
Okay, I have to excuse myself. The Vice Chair can close out the meeting for me. I appreciate everybody.
Hey, thank you. So I'll just turn to the fourth priority. And Ramirez, you brought up, I wanted to make it clear to the board what this ask is. This is a separate ask than the third priority, which is, that additional staff member here in our office. We will continue ethically and legally have to continue to contract with outside counsel to represent clients for conflict of interest cases where otherwise, prohibited from representing. And of course, those contract counsel will as well need the services of investigators. Since it's a conflict of interest case, those conflict attorneys, not that our internal investigator would have the capacity to take additional work from outside this office, but they have to rely upon the services of independent contracting investigators. So my request here, I hope that's clear, is to increase that professional service, the independent contracting investigators that serve and work with our conflict counsel to raise their hourly rate from $40 an hour to $50 an hour. And I put this on as a request because as Jose and I were going back over numbers, and it's also based on feedback from the independent contractors that do investigations that have asked me, is there a rate change coming? Jose and I did do some research on when that rate was set, the current $40 an hour, and we couldn't find it going back 10 years on when it was set, but we know it's been $40 an hour for 10 plus years. So my request is to stay market competitive, to increase that $40 an hour to $50 an hour. It's a modest hourly increase. We project based on the services that we've seen, if it was funded and we did increase the hourly rate by $10, And we're looking at an annual increase in expenditures of a little over $11,000 or about $11,000 a year. I make this request, again, as not just, on their behalf, but as the director of the department. These are vital services. They have to be performed, and I have to be able to retain and recruit outside investigators to work with our conflict counsel so they can do their job. And it's one of my responsibilities is to try to keep a group of contractors here in our community to do this specific work. And at some point, I'm going to lose contractors because we haven't paid them any more than we had, 10 plus years ago.
The county commissioner, the county manager's got a comment for you.
Okay.
So this is similar to when the board increased the hourly rate for panel attorneys 3 years ago. So it's just about the same, it's keeping up with the market rate, okay?
I'd say that's analogous, Romero, keeping up with the market rate and staying competitive, right? Because, we value their work. They do excellent work in cases. And, I'm not the economist. There are others here that can do that. But over the course of 10 years, I think increasing a rate by $10 for just general cost of living, inflation, you name the rest is fair. If there are any other questions about that ask, I know it sort of seemed maybe a little confusing as to what that ask is, but I hope that's clear now.
No, you got it.
Okay.
Any questions, Commissioner?
No, sir.
Okay.
You about got it? That's about it?
That's all I have in terms of policy level requests. I will say that we'll make sure we follow up with that additional information for the board to make their decisions. Apologize for the oversight on the typo in terms of the training budget. It certainly isn't that big a ask, much more modest than that.
Okay, Patrick, thank you very much for your presentation.
All right, so
Yeah.
And we're about done here.
hang on.
And I am now going to adjourn this
Wait,
meeting.
wait.
Oh, we got a question.
We've got a hand up from staff. Denise.
Denise, go ahead.
Thank you, Commissioner. I would just ask if you could please leave your budget binders on your desk. I'm going to be in early Monday morning, just a couple of financial plans to add to your binder. And I'm just swapping out a cover on the correcting time and date of presentations for juvenile and superior court.
You need to take it with you.
No, nothing fits in my binder anymore.
The binders are full.
Okay, we'll do that.
Challenge accepted.
Okay.
Thank you. Thank you. Good job, Patrick. Thank you. And Jose and budget team. And have a great weekend, everyone. And now.
And it is 8 minutes after 4 on Friday, October 8th, 2021. And we are adjourning this budget meeting. Thank you all.
All right.
Yay.